Mai ki tēnā hui. Ko Robert Scott tōko ingo. Welcome everybody. This is day one of the first hearing of the Far North District Plan, the proposed Far North District Plan. My name is Robert Scott. I'm the chairperson for these hearings, and these will be hearings that will be over the next 15 or even 18 months. This hearing panel is made up of 9 members, 9 commissioners, 4 of which are elected commissioners and 5 are independent hearing commissioners. We're fortunate today to have had all 4 of the elected members with us, and they are, well, Commissioner Hilda Harawera. She's had to actually leave because she's feeling unwell. But fortunately, Commissioner Steve McNally, who is one of the 4 elected members, is going to be sitting in for her today. Hopefully Commissioner Harawera will be back tomorrow. We also have Felicity Foy here, who's an elected councillor, and Kelly Stratford. She's sort leave because her ill grandmother. The 5 independent members are myself, Commissioner Alan Watson, Siani Walker, and Bill Smith, who is just sitting over here, and Peter Kensington, who's sitting beside Commissioner Smith. So welcome to all of you. So this is a hearing held under the Resource Management Act, and it's to consider submissions and further submissions on the proposed Far North District Plan. We've been appointed by the council as independent hearing commissioners to hear all of these submissions, and we're going to be making recommendations to the council on any changes to the district plan as notified. We are not intending to issue interim recommendations on the plan at this stage, and we will be hearing all the submissions prior to issuing a single recommendation report. That said, we intend to hold interim deliberations at the conclusion of each hearing topic, and then we will bring those together once we've heard all the submissions. This way, as a way of a brief introduction, my background is in town planning. I've been a planner since last century, 1992, and an independent commissioner since 2014. I mainly practice in Auckland, the North Island, and in Queenstown. I'm also a commissioner for Gisborne, Tairāwhiti, Napier, Tauranga City, the Waikato, and the Bay of Plenty regional councils. I'll just get the other commissioners to briefly introduce themselves. Start with you, Commissioner Watson.
Yeah, good morning, everybody. Yeah, my name's Alan Watson. Yeah, I'm a town planner too, although I confess I haven't done any town planning work for a long time. I work mainly as a commissioner around the country. I think my commissioner experience runs to about 35 different councils nationally. And I also present for MFE on the Good Decisions program, which is something I've been involved with for a while. So yeah, welcome, pleased to be here, and hopefully I can be of assistance. Cheers.
Tēnā koutou katoa, nā mahine kia koutou katoa, ko Siani Walker tēnei, he mahi ana ahau, hei Resource Management Planner, Commissioner, Advisory Trustee for iwi, I don't know. Kia ora, my name's Siani Walker. I am a Resource Management Planner and Policy Planner by profession, and I also do advisory work with my iwi in Wanganui, Ngā Tangata Tiaki, Te Awa Tūpua legislation, as well as other roles that I have on the Wanganui River. So background, lots of policy planning at Auckland Council, lots of regulatory planning across Aotearoa with consenting, and Commissioner resource consent hearings down on Bay of Plenty Way. So kia ora koutou.
Tēnā tātou katoa, ko Steve Foy Tukungoa. I am a Far North District Councillor, as our chair has outlined. However, my formal background is in town planning, and I'm a full member of the New Zealand Planning Institute. Also am a beef farmer. I'm a mother of 2, and we also have a plumbing and drainline company. So a diverse background, and really grateful to have this experience as a commissioner.
Morning, everyone. Steve McNally. I'm an elected member of the Far North District Council. Kaikohe is my home, actually. Went to school here, and before I went off to university, my background in property is valuation, 84 to 2010 up here in the far north. And I'm still farming a few cattle and sheep, lease bit of land. So with my valuation background, come across a lot of planners over the years. It's been fun.
Yeah, thank you. So the hearing that we have before us over the next 3 days involves the following topics. Part 1, the introduction and general provisions. Part 1, tangata whenua, and Part 2, strategic direction. Now, before we hear the first submitter, and I see they're raring to go, we are going to get the council officers to introduce these various topics to us. And we will be asking them to do that in a minute once I finish my introduction. We do have a couple of procedural matters that we just need to address first. And there's a particular relevance to our first submitter because it relates to their late further submission. In minute 2, we issued a direction regarding late submissions. We've been advised that a further submission by the Yates Family Trust, that's further submission 384, was not included in that direction. We have conferred and agree with the reporting planner in the 42A report that this further submission should be accepted for the reasons set out in minute 2. The 42A report also refers to 2 further submissions that should be rejected as they were not related to the summary of submissions addendum, and we agree with that recommendation also. I also understand that there have been a couple of missed submissions that haven't been fully recognised. So that came to light late last week. So we'll just ask the council officers to just address that matter now while we're addressing these procedural matters. So I'll go to Tammy Wooster, who's the manager of policy, to address that.
Thank you. On behalf of Council, I would just like to raise the following 2 procedural matters. The evidence of Audrey Campbell Frere, submitter number 209. For strategic direction, we received evidence from Audrey, primarily relating to rezoning. This submission was not evaluated in the strategic directions for section 42A report due to this. The submitter is entitled, however, to raise these matters at the strategic direction hearing, as we acknowledge that the strategic direction plays a role in setting the framework for zoning, and the submission points can be dealt with at the rezoning hearings, for example, rural zones. We intend to consider the evidence provided by Melissa McGrath on behalf of Audrey and directly respond to and address the points raised in evidence in my right of reply. It was also identified that some submissions, some hard copy submissions had been missed. It was 5 valid further submissions received on time, which was the 4th of September 2022. They had not been entered, unfortunately, in the spoken submission tool. They relate to Peter Malcolm, who was further submitter number 584, 585, 586, and 587. Also Ian Taylor Bamber, further submission submitter 588. Some further submission points of these submissions are relevant to hearing 1, all 3 of the topics, and have since been added to Appendix 2 of the submission summary tables of the relevant reports, but they do not change the overall recommendations of the officers. Peter Malcolm is aware of the situation and will be attending hearing 1 to speak to a submission point. To the submission 584.008, he is scheduled for 9 AM on Wednesday, the 29th of May. Ian Taylor Bamber did not respond to the request to be heard for his further submission. In Council's view, the delay to summarise these further submissions does not result in any change to Section 42A reporting or overall programme. It does not change Council officers' recommendations on relevant matters, nor does it result in an unfairness, as these further submissions have been treated the same way as all others received in time and of a similar nature. Does the panel have any questions?
Thank you very much. We're happy to accept that.
Can we get that in writing?
Yes, so could that be provided to the panel in writing?
Certainly will
Send that to the hearing administrator.
Would you also, sorry, like that to be put online? or just to the panel?
I think it should probably rest as an addendum to the 42A report. So maybe you might want to give it that title as an addendum. Okay. Now, for those of you who have not been to a district plan hearing before, the usual process following the council's introduction is to call on those submitters who want to be heard to present their evidence as set out in the timetable, which is also on the hearing page. Now, as commissioners, we might have questions of any of those submissions, and those questions can be asked through the chair. We don't allow anybody else to question those submitters, and if anybody wants to raise a point of order, it has to go through myself. I just want to make, you'll see that a number of us have some laptops in front of us. We're all trying very hard to be as paperless as possible, with some success and some failures at times. So if you see a laptop in front of us, please don't think that we're updating our Facebook profile or watching cat videos on YouTube. It is that, particularly myself, I have all the evidence on me on the laptop, as well as the questions that I have set up to ask. So if you see me working away on the laptop or any of the other commissioners, please be rest assured that we are looking at relevant materials. And before we proceed, we just need to deal with some housekeeping matters. So I'll pass over to our very competent hearing administrator, AK, to deal with those matters.
Good morning, everyone. So for those of you that don't know, the restrooms are straight out these doors and turn right. These bathrooms down the hallway. In the case of a fire evacuation, which we hope doesn't happen, please head out the nearest exit, which will be that front door. Or if we can't get out the front door, please follow the council team and we will head out a back door. And gathering place is over on the grass area past the car park, just past the Kaikohe hall. Please make sure you've all switched your cell phones off, or at least popped them onto silent, just so you know. We are recording today's session. What the people online can see is not what we can see in this room, so they are able to see the complete room. And so do just be aware, anything you say will be recorded and this will be posted online to our hearings website later. Break times today, we are aiming for lunch from 12:15 to 1:15 and then an afternoon tea break at 3:30. If anyone decides they would like to record the session themselves, they will need the permission of our hearing chair, Robert, so please make sure you do that. And that is it from me.
Great, thank you very much.
Yeah.
Now, Ms. Wester, hand it over to your team to introduce the sections of this hearing.
So tēnā koutou everyone.
Oh,
My name.
no, sorry, I have forgotten one matter. We just need to make a statement regarding conflicts of interest. So I'll just go quickly around the panel. Myself, I don't have any clients or family up here in the whānau, so I have no conflicts of interest. Commissioner Watson?
Yeah, no conflicts.
I previously was a consultant planner and a staff member at the council, but no conflicts.
So I have putting a declaration out there that Bentley and Co prepared a submission for Waste Management New Zealand, and I had nothing to do with that particular submission. So I would recuse myself from hearing or deliberating if anything comes up on waste management. Also, I have no conflict. Foodstuffs North Island Limited have done a submission, and Bentley and Co have them as a client, and Bentley and Co have not been a part of any preparation for the Foodstuffs North Island submission or preparation. That's it for me.
You're an employee of Bentley and Co.
Aroha, yes, an employee, a director of Bentley and Co. Kia ora.
I'm just trying to think. Now, my involvement now, other than with council, is more with my own lease property. So I chase sheep and cattle around more than I do anything else. When anything comes up, I'll excuse myself.
Okay, thank you. Okay. Sorry for that interruption, but we'll now pass over to you to do your introduction, Ms. Wester.
Tēnā koutou everyone, as advised by the chair earlier on, my name is Tammy Worcester. I'm manager of the Integrated Planning Department. That department is responsible for the district plan team. So I'm here today as the reporting planner of the strategic direction hearing report. My other two colleagues will speak as well in relation to their own that they'll be talking today. We're taking it as the reports have been read, not get into the finer detail. So basically, for each of these reports, topics, we're going to do an overview of submissions and recommendations, key matters of contention for consideration at the hearing, and the other two topics being talked to today are tangata whenua and part 1, plan works and general miscellaneous. Just waiting for the screen perhaps to catch up. Oh, I'm on this other slide.
You go, so I think. I think it's on.
Thank you.
If not, just nod to me afterward.
In relation to the strategic direction topic, there were 63 original submissions with 321 individual submission points. There were 225 further submissions with 853 individual submission points. There were 131 original submissions points, which indicated general support, while 133 submissions points indicated support in part. And there were 25 submission points opposing the provisions. Submissions came from a range of groups or people, iwi and hapu, interest or advocacy groups such as community groups, other organisations, community members, meaning general public, government organisations, and also utility operators. The key issues raised in submissions relates to consideration of higher order direction, the zoning framework that falls out of the strategic direction framework, importance of climate change, urban design considerations, objectives being all inclusive, and the question over inclusion of policies. In relation to the higher order direction, that related to the National Policy Statement on Urban Development and Highly Productive Land. Recommendations were related to duplication and chapter overviews, greater consideration of the transportation network, addition of additional infrastructure to consider infrastructure more broadly, and there were also minor amendments to wording. The key matters for consideration relate to the zoning framework, urban growth and rural productivity, regional significant infrastructure in relation to also infrastructure in general, new strategic objectives, and how submissions are dealt with. That's in relation to should some submissions perhaps be deferred to other hearings, because we don't know, for example, outcomes for things like housing and business assessment that's being done at the moment, for example. I'll hand over to my colleague Teresa unless there's any questions.
Ko wai ahau, nō tuku ahau, he uri o ngā hapu ngā tumurika me putakuri, me ngā iwi o ngā tikuri me te ranga, which is here kāwhai. So I'm hail from Te Hiku, or how we affectionately call it in the far whānau, for the real whānau. Ni kaitaia. I am a nuri of my hapu a Ngāti Muri Kātara me Kirikiri mai iwi Ngāti Kuri me Te Rārawa. I am a senior policy planner in the district plan team. So today, relevance for me is the tangata whenua chapter, and here you can see the overview of the submissions to the tangata whenua chapter. 23 original submissions with 201 individual submission points, 168 further submitters with approximately 1,600 individual submission points, 79 original submission points indicated general support for the provisions. to be retained as notified. 39 submission points indicated support in part. Changes requested. 62 submission points opposed the provisions and 21 submission points record not stated in response to support opposed positions. Submissions came from iwi hapu, marae and whānau groups, interest advocacy groups or organisations, community members, government organisations and utility operators. The key issues in this chapter were the chapter overview, issues around the objectives and policies and general issues related to wider matters, process, and content, purpose, miscellaneous, significant resource management issues, definitions and the glossary. The recommendations may include that an additional paragraph in the chapter overview, a new objective and amendments to objectives and policies, replacement of words in the significant resource management issues and amendments to definition. So you have to see or remember, we'll do that.
Tēnā koutou. I'm Sarah Trinder, reporting planner for Part 1 General Miscellaneous. So we received 89 original submissions with 199 individual submission points, 207 further submitters with 740 individual submission points. 21 of those original submission points indicated general support, 74 indicated support in part, and 38 were opposed to some of the provisions. Submissions came from iwi and hapu groups, interest or advocacy groups, organisations, community members and government organisations. Some of the key issues were around the whole of the plan submissions on process and consultation, how the plan works, plan-wide general topics, the introduction of new chapters, general clarifications and matters that were outside the scope of the district plan. Some of my recommendations included minor amendments to the significant resource management issues, minor amendments to the general process section, detail around applications subject to multiple provisions, plan-wide amendments that require further consideration. Some of the key matters of consideration are the overlays and the enabling overlays that inclusionary housing and contaminated land chapter. That's the end of our presentation.
Well, thank you very much. That was quite a comprehensive introduction. If not already, is that available? Can be made available on the website? Thank you. Got any questions? Well, thank you. We've got no questions for you at this stage. However, at the end of the evidence presentation, we'll give you an opportunity to respond to the evidence that's been presented. And I understand that you'll be doing a written reply statement following the close of this evidence. Okay, well, I think we're now ready to hear our first submitter, Mr. Hall and Ms. Beresford. Hello, welcome. Mr. Hall, we've received your evidence in advance, and so we have read it. So we'll probably be looking to you to provide us a summary and any other matters that you may wish to raise, perhaps with regards to other evidence that we've presented. We have received your legal submissions, Ms. Beresford, but I have to confess I have not read them yet.
We've got the required hard copy.
Yes. So you are welcome to read your legal submissions or provide us a summary of them.
Thank you.
And put that would be in your hands with regards to how you'd like to proceed. So if you'd just like to just quickly summarise which submitters and further submitters you're representing.
Tēnā koutou. Good morning, commissioners and panel members. and Chair. These legal submissions and the evidence from Mr. Hall are presented on behalf of Benson Farm Limited, CETA 36 Limited, the Shooting Box Limited, Matodi Trustee Limited, P.S. Yates Family Trust, and the Matica Station Residents Association Incorporated. Paragraph 1 of my legal submissions, the footnotes there set out the series of submissions and further submissions that have been lodged by those submitters. So I am here as legal counsel. I have with me Mr. Hall, who has pre-circulated his planning evidence as well. Now, there's essentially two reasons why this group of submitters are here at this strategic directions and general hearing 1. The first is to introduce themselves and also their land holdings, and then also to discuss the amendments that have been sought to the relevant chapters through submissions, and you know the reasons for those as well. And what we thought may be useful is in terms of the first part, the introduction of the submitters and their land holdings, is that before I get into my legal submissions, is actually to ask Mr. Hall to take the commissioners through those land holdings and a little bit of a guided tour, so to speak, and take you through that part of his evidence. Then we'll turn back to my legal submissions, and then we'll return back to Mr. Hall's evidence in terms of the amendments. I could hand over to Mr. Hall.
Okay, one matter I just wanted to raise quickly was we haven't got microphones here, so we're not amplified. At the back, can you hear our voices okay? Okay, so I just want to say to all participants, feel free to raise your voice and make sure that everyone can be heard, but it looks like you've got the right level of volume, so please continue.
Tuatahi ka nui te mihi ki te tangata whenua te iku. Tēnā koutou I te ngā tangi ki ata nei. Ki te Kaikohe hera, tēnā koe, tēnā koroa, and te rami ki te komiti katoa. Ko Peter o toku ingoa, no Tamaki ahau, e kai whakamahiri ahau planner. So I'm presenting today on behalf of the clients that Jane has outlined. I spent some pages in my evidence, as you might have seen, introducing the clients. It's just simply put this time that we will be appearing on their behalf of the panel. And there's a bit of a program ahead of other hearings that we'll be presenting to. So I thought it useful to essentially say where they are and what their key interests are. So I'll summarise that, but if the committee has it in front of them, then the attachment 3 to my evidence has a location map of the submitters' interests, land holdings in the district. And I'll just speak to those broadly, as I say, it's covered in my evidence. But starting with Benson Farms Limited, so they own 560 hectares of land in the Eastern Bay of Islands, the Harakura harbour or bay, beside the Rafiti Peninsula. And previously, and through the previous plan review process, they undertook a subdivision of that land holdings, and that's known as Omarino, which comprises 17 lots. And that's a management plan subdivision. That's one of their key interests in the hearings coming up, is the management plan subdivision provisions. But also, and importantly for them, the Omarino is part developed and part unsold also. And so they are keen to ensure that the entitlements that that subdivision established are retained through the various overlays through the plan process. And that's a bit of a theme which that'll be developed further through subsequent hearings. So Omarino is a management plan subdivision. The property has been extensively, in fact, was entirely revegetated with 1 million native plants planted over that time. It is well established now house lots which are as yet unbuilt. We'll be talking further about. Benson Farms is the 560 odd hectares inland of that, and Benson Farms again are interested in management plan subdivision provisions and subdivision in general. That property, although it's both properties are rural zoned, Omarino doesn't, it's not rural productive land. it's subdivided down to between 4, 5 and 6 hectare allotments. Benson Farms at face value may be seen as rural productive land, but it's almost, or in large part, covered with native vegetation, with not a particularly productive portion of paddocks as part of that too. So that's Benson Farms. The next one I'll turn to is the Shooting Box and P.S. Yates Families Trust. Those are 2 adjoining properties across the opposite side of Parakura Bay in the same vicinity. Small properties, respectively 7 and 4 hectares plus additional lot they have. Those properties are almost entirely covered with native revegetation, and they're occupied with houses by those landowners. Again, rural production zone. Next, I turn to the Mataka Residents Association, and that's at the opposite end of the Bay of Islands, out on the end of the Pururura Peninsula, and around Mataka itself. That is a conservation estate. It covers 1,150 hectares of large land holding. It was subdivided in the early 2000s. Effectively, there's 30 residential properties there. There is a working farm on top of that as well, and various overlays. And as with Omarino, extensive conservation work has been undertaken, fencing. The property features one of the highest kiwi population counts in the country, and that conservation work is funded in large part by the residents. The majority of the properties are as yet unbuilt. So again, one of the key concerns is to ensure that those entitlements under the subdivision are retained through the process. And to that end, Mataka seeks a special purpose zone across its land holding. And so that will be a topic which will be presented in much further detail, obviously, at a much later date, at the back end of the hearings. Matori Trustee Limited, that is a property just to the north of Matori Bay. It was purchased by Sir Doug Myers in the 1970s and 80s, and since his passing, it is now owned in trust on behalf of his 3 children. So Matori Trustee, that's 339 hectares of coastal farmland. The family have done extensive conservation planting, wetland enhancement work on the property. Their interests are both on the farming side to ensure that the provisions allow for reasonable farming use on the property, but also on the subdivision side. Recently, the family obtained consent for 2 additional houses on that property, and the objective there is that they will return to occupy that property in time. So Matori, as I say, have interests at various parts of the hearing, which we'll be presenting on as well. That's a broad overview of those submissions. I've included pictures in my evidence of their land holdings, so you get a bit of a sense of the lay of the land, and we'll be talking in much further detail about those submitters and their interests in due course.
Thank you. Has anyone got any questions?
Just those pictures, or as you refer to them as photos, are particularly helpful, so thanks for those.
I will pick up and resume, take you through my legal submissions. Appreciate the indication that not everyone has had the opportunity to read them. There will be some things that I still think I'll be able to take as read because it's set out there, but generally will take the panel through. So starting at paragraph 2, as Mr. Hall has just explained, the submitters own rural coastal land in the north of the Bay of Islands, and that's proposed to be zoned rural production under the proposed final district plan. The submitted properties all have low density coastal rural residential lifestyle component to their land use. These developments have been sensitively designed to be sympathetic of the natural environment with an emphasis on environmental conservation and restoration. While some of the properties include working farms, the properties are not all necessarily highly suitable for primary production. The submitters generally support the approach taken by the Far North District Council and the strategic direction that were notified in the PDP. And so in terms of having attended the welcome this morning, to acknowledge, it was actually very heartening and a reminder to acknowledge the level of work that has gone in from the council officers to get to this point. And would like to sort of say at the outset, we're here in a spirit of improvement. There will be things that we disagree with, but generally it's because on behalf of our clients, we think there are areas of the plan where amendments will make improvements. And having said that, so the submitters are concerned that the PDP and officers' responses to their submissions and the Section 42A reports do not properly recognise that non-primary production activities are strategically important land use in rural environments. The submitters seek for the PDP to create a strategic policy framework that sufficiently recognises the benefits of coastal rural residential development, particularly that which delivers conservation outcomes. So in relation to the topics for this hearing, one, the submitters seek amendments to introduce a new strategic objective in the strategic direction chapter rural environment to recognise and provide for the importance of non-primary production activities in the rural environment and the contribution they make to the well-being of the district. Further amendment to recognise the importance of restoration as well as the protection of natural character and natural landscapes and features in the natural environment. That's an amendment in the strategic direction chapter, natural environment. And to clarify that overlays and their provisions only apply to the parts of properties where such overlays are mapped. It is submitted that the amendments sought by the submitters are required to better give effect to the sustainable management purpose of Part 2 of the RMA, the statutory tests for district plan making under the RMA, the applicable national policy guidance and the New Zealand Coastal Policy Statement, the regional planning framework, and the 80-year vision for the district's environment as articulated in FAR Northern 2100, an 80-year strategy for the district. The submitters intend to call one witness, Mr. Hall. I've already spoken to you. He has particular expertise in rural residential development in sensitive coastal locations. His evidence introduces the submitters and the particular attributes of their land holdings, outlines the topics and hearings that the submitters expect to present at during the course of the PDP review hearings, and explains the planning rationale for the amendments sought by the submitters. And just on that note, it's probably worth pointing out that in one of the annexures to Mr. Hall's evidence, which is where we're going. So as we've sort of indicated, we'll be appearing a few times during the course of the next 18 months because the matters raised by this group of submitters do fall through multiple hearings. So we've tried to give the panel a roadmap of where we'll be and what the key issues that are going to be raised in each hearing are. And so that's an attachment to Mr. Hall's evidence. It's indicative because things will no doubt change and refine and become more focused as we go through, but that's how we see it now, and hope that that's of some assistance. So I've set out at paragraph 7 the matters that I intend to address. I'll give you an overview of the submitters' interests and their general position. I've set out the legislative framework for district plan making, including around strategic objectives, and then the analysis part of my submissions where I talk about the statutory and policy reasons that support the amendments that are sought by the submitters. So I'll take you through my section on the submitters' interest and position. Mr. Hall has already taken you through sort of on a property by property basis, but what I've tried to do here is to draw together some sort of key themes about the properties and the position. We'll talk at later hearings more specifically about individual interests, but this is just that high level overview as a starting point for this hearing. So the submitters' land holdings are in coastal or island locations in the Bay of Islands or to the north of the Bay of Islands in the case of Matauri Trustee Limited and their property at Opanui in Matauri Bay. The submitter's properties are all zoned rural production and are subject to various coastal or conservation overlays over either all or parts of the properties. The submitter's properties successfully combine spectacular coastal landscapes, natural character, beaches, farmland, conservation reserves, and wildlife with private homes that have been carefully designed to integrate with the natural environment. Omarino and Matika Station have a proven track record in delivering exceptional quality rural residential development in sensitive coastal locations within the Far North District. Larger properties, such as Matika Station and Omarino, have been master planned to international standards, enabling owners to enjoy private homes and the natural beauty of large properties with beaches, farmland, and conservation land. For example, as Mr. Hall mentioned, the conservation estate at Matika Station has been extensively fenced and planted in native vegetation, providing a home for one of the most significant Kiwi populations in New Zealand. At Benson Farm, there has been an extensive program of riparian planting and fencing. Significant revegetation has occurred at Omarino. Quality development is ensured by covenants requiring compliance to design guidelines at both Matika and Omarino. Matoni Trustee Limited's Opunui Farm has been the subject of extensive conservation work, including pest and predator control, wetland and bush fencing, and native bush restoration. Across all of the submitted properties, there is a strong kaitiaki or stewardship ethos. New homes and buildings have been designed to maintain high standards and a degree of design integrity that is sympathetic to the landscape and the character of the land as a whole. The focus of the submitter's coastal rural residential development has been on integrating limited development sensitively with the natural environment and on preserving the quality of natural assets and the conservation experience. Turning to the submitter's position, although the properties are zoned rural production under the PDP, farming activities are either undertaken in conjunction with rural residential development, in the case of the larger properties, or not at all in the case of the smaller properties, where the size and extensive native vegetation cover means that farming activities are non-viable. Even for the larger properties, the extensive native vegetation cover, along with other site-specific factors, which is something we'll discuss at later hearings, means that the farming activities could not really meet the level of economically viable primary productive use. For Matika and Omarino, it has been the rural residential development that has enabled the conservation and restoration works at the properties to be undertaken. So against this background, the zoning provisions, overlays and other planning tools that are proposed to apply to each property are matters that will be discussed at later hearings. However, the submitter's overall position is that while the PDP is generally supported, amendments are required to ensure that the PDP adequately provides for coastal rural residential development, including in the case of Omarino and Matika, development that has already been approved. And that's quite an important point for those submitters, that there are development rights that they will want to see continue under the new plan. In relation to this strategic directions hearing, the submitters say that the amendments that they have sought are required to establish an appropriate high-level policy framework. The next section of my submissions sets out the legislative framework, particularly in relation to district plan making principles, which I'm proposing to take that as read. I expect this is all material that will be familiar to the submitters. It is there should you need it. I'll just make the comment that in my section for the reasons for the amendment, they do link, it does link quite closely back to what I've said in terms of the district plan making and the legislative framework. There was one point that I did just want to highlight in that section, which was at paragraph 23B, where I've just talked about that in terms of preparing a plan, a council, the case law is required to start with this clean sheet and focus on the purpose of the RMA, that a plan should be forward-looking, but it also needs to be based on the existing environment such that it's never zero-based. And I'll discuss that a little bit in terms of what the existing environment is and what we're dealing with here in terms of primary productive use or non-productive use, because I think that's quite a key point. So that takes me to paragraph 27, where I did want to make some comments about the national planning standards and strategic directions, because this is slightly outside of the standard district plan making requirements that I'd expect the panel to be more familiar with. So among other relevant considerations, the PDP must be prepared in accordance with the national planning standards, and once approved, it must give effect to those standards. The purpose of the standards is to improve the efficiency and effectiveness of the planning system. The standards require the inclusion of a strategic direction section within a district plan. The relevant matters that, if addressed, must be located in that mandatory section, include an outline of the key strategic or significant resource management matters for the district, and objectives that address key strategic or significant resource management matters for the district, and guide decision-making at a strategic level. So the standards are not the authority for including strategic objectives. Rather, they prescribe the proper location of such provisions. The legislative authority for council to include strategic directions and to determine their content and how they will apply resides in the district plan making requirements, provisions of the RMA that I've set out above. In addition, given that district plans are to be interpreted as a whole, the Environment Court has recognised the need for strategic direction provisions to address the intended relationships with other chapters in the plan. Where the strategic direction chapter of a district plan is expressed as having primacy over the other objectives and policies in the plan, then those provisions must be expressed and achieved in a manner that is consistent with the strategic directions. Now, the case law on strategic directions is not particularly fulsome, and I'd say it's perhaps a little bit light. It's more sort of examples of how things are applied in a particular district plan context, but they are there. I've set out a couple of examples should that be of assistance. According with the directions, I have provided links to the cases. If there's anything that doesn't work, I'm happy to test it. I'm happy to make those available if there's anything that the panel needs. So turning now to the most substantive part of my submission, which is the reasons for the relief sought by the submitter group. So the first topic to address is the new strategic objective to recognise non-primary production activities. The submitters are seeking to have a new strategic objective, and that would be added as SDRE02 to the strategic direction chapter rural environment, to specifically recognise and provide for the importance of non-primary production activities. It is submitted that the inclusion of a new strategic objective will better fulfil the Council's statutory plan making obligations. This is because by recognising the diversity of the existing and potential land uses at a strategic level, this better enables the development or protection of natural and physical land uses in a way that enables social and economic well-being. Acknowledging these land uses at a strategic level provides a more realistic and workable framework for the other chapters in the PDP when considering the positive and negative effects of non-primary production activities. The district's rural environments are key settings for matters of national importance, including the coastal environment, outstanding natural features and landscape, and areas of significant Indigenous areas. In my submission, acknowledging at a strategic level that non-primary productive land uses occur in the rural zone and have the potential to both benefit and affect these environmental values is an essential first step to recognising and providing for these matters of national importance. Without the proposed strategic objective, the PDP's strategic direction would fail to recognise a land use that is occurring in rural environments. Such land uses are realistically expected to continue and to deliver environmental and economic benefits to the district. Without acknowledging this at a strategic level, in my submission, there is a lacuna in the PDP's strategic direction. It is difficult to see how the PDP would appropriately support council to achieve integrated management in its district if recognition of such an important land use is absent from the PDP at a strategic level. And just to comment on that, I think the phrase that came to mind when I was preparing the submission on this is one that we're familiar to planners: what you measure, you manage. And so it is important to have a comprehensive strategic framework that does address the land uses that are occurring and that will continue to occur. The proposed strategic objective would make this section of the PDP more coherent. It would be consistent with the strategic directions overview, which provides that strategic directions are intended to demonstrate integrated management through the grouping of environmental considerations, which combine to achieve strategic outcomes and avoiding strategic objectives becoming isolated within the various chapters of the district plan. The overview section of the strategic directions chapter records this chapter sets out the overarching direction for the district plan and helps to achieve and aligns with the community outcomes set out in Far North 2100, and that for the purposes of preparing, changing, interpreting and implementing the district plan, all other objectives and policies and all other chapters of the district plan are to be read and achieved in a manner consistent with their strategic directions. There's no hierarchy between the stated objectives, i.e. no one strategic objective has primacy over another strategic objective, and the strategic objectives should be read as a whole. So in my submission, having opted to include a strategic directions chapter in the PDP on the basis that all other chapters are to be interpreted in light of and read consistent with the strategic directions, the strategic directions need to be complete and meet the statutory requirements for decision making. So in terms of your section 32 assessment, there's no presumption that the council's notified version of the PDP is most appropriate. In terms of giving effect to higher order planning documents, the Northern Regional Policy Statement does not really provide any clear guidance on this matter, and in my submission, there's no issue in including the amendments sought by the submitters. In terms of the requirement to have regard to management plans and strategies prepared under other acts, it's submitted that the most relevant document to the district stated resource management issues is Far North 2100. So there's quite a lot in Far North 2100 in my submission that would support the introduction of this new strategic directive as sought by the submitters. So I'll take you through my submissions on that. So as you'll be aware, the district strategy that describes how the Far North may look in 80 years' time, and it's based on the vision for the district, He Whenua Rangatira, a district of sustainable prosperity and well-being. It takes on board the things that will influence the district's future from a global, national and local perspective, and considers its place in New Zealand and the challenges that must be overcome. Importantly, Far North 2100 identifies stewardship, environmental prosperity as one of the 5 key drivers of focus, meaning that people who make up the communities of the Far North nurture their natural resources and ecosystem. There's a culture of stewardship in the community that promotes biodiversity and environmental sustainability. The social, culture and economic activities in the Far North are aligned with our expectations for the environment. The strategic directions overview records that the strategic directions are intended to demonstrate alignment with council's aspirations for the development and environmental quality of the district as expressed through the strategy. The submitters say that given the potential environmental and economic benefits of non-primary land uses, recognising these land uses at a strategic level in the PDP better aligns with the long-term aspirations of the district as set out in the strategy document. Further, the opportunities for environmental enhancement and conservation restoration associated with these non-primary production land uses would provide better alignment with the vision for a culture of stewardship in the community that promotes biodiversity and environmental sustainability. So turning now to the next amendment sought by this group of submitters. The submitters are seeking that SD NE05 be amended to recognise the strategic importance of restoration of natural environments in addition to their protection. And essentially the submission here is that they're 2 distinct concepts, both of which ought to be recognised at a strategic or high level in the PDP. So the reporting officers do not consider that the amendment is necessary because they take the view that the strategic objective directives are not intended to address all of the matters of national importance, as these chapters are only intended to identify and respond to resource management issues considered to be of particular importance to the district, and that the reference in that strategic objective to ensuring the long-term protection of future generations is sufficient to link the policy back to the NZCPS. So the submitters disagree with both of these reasons, and just referring back to something that I said earlier, I think this is one of the opportunities for improvement to the PDP through the submissions and hearing process, because it is an important concept that's in my submission worthy of including at that higher level. So in this case, while the list of significant resource management issues does not specifically promote restoration of the natural environment, the description of the district contained in that chapter does record that land use change, among other things, represents significant challenges to the maintenance and enhancement of the district's natural environment and ecosystems. In my submission, this does recognise the need to enhance the natural environment as an important issue for the district, and the inclusion of restoration in this objective would be entirely consistent with this approach. Further, Council has a firm obligation under Section 75(3) of the RMA to give effect to or implement the NZ Coastal Policy Statement as a whole. It is submitted in an oblique reference to long-term protection of future generations on the basis that it is sufficient to link back to the NZCPS, is not sufficient to fully give effect to that national policy statement, which has clear directives to provide for restoration. And I've set out there objective 2, policies objectives for the New Zealand Coastal Policy Statement. I've pointed out that policies 13 and 15 deal with identification of and the preservation and protection of the natural character and natural features and landscapes respectively. However, it is policy 14 that deals separately with restoration. I've set out the relevant parts of that policy for the panel in my submissions. Paragraph 41, the NRPS also includes directions to maintain or improve outstanding landscape and natural character values, and to, where possible, enhance Indigenous biological diversity. And in relation to considering the effects of proposals on natural character and natural features and landscape values in the coastal environment, requires having regard to restoration and enhancement. In my submissions, not specifically including the restoration element and the strategic objectives of the natural environment, we've ignored that restoration is identified as a separate concept in the objectives and policies of the NZCPS, and will not properly give effect to those high-order planning instruments. So turning now to the last amendment sought by the submitters in relation to this hearing, the overlays. The submitters are seeking an amendment to the general approach chapter of PDP to clarify the effect of overlays being applied to part of the site as follows. Set out the amendment that's sought. Essentially, in relation to the submitters' properties, there are various overlays that apply only to a portion of the site. So any subdivision and development proposals are going to need to be carefully designed and very sympathetic to those, and that's appropriate. As explained in Mr. Hall's evidence, the proposed amendment would give greater certainty and clarity to plan users and would make the PDP more workable. In terms of Council's district plan making requirements discussed above, the first step in the protection and preservation of natural character and natural features and landscapes is correctly identifying where there are environmental values that warrant protection, and then the planning response to those values is to be considered separately after. In my submission, ensuring that the PDP is clear about where those overlays apply and how they apply is consistent with the approach of first accurately identifying where such environmental values exist. So in conclusion, the submitters say that the amendment sought will improve the clarity and coherency of the PDP and better fulfil the statutory decision-making requirements. The amendment sought provide the most appropriate way to achieve the purpose of the RMA for the reasons discussed. including the amendment sought acknowledges the existing range of activities occurring in rural environments and better enables the PDP to be forward-looking to future land uses. Happy to answer any questions on my submissions.
Yeah, thank you very much for those legal submissions, Ms. Beresford. I do have a couple of questions, but they're probably more planning related. So what I think I might do is I might hold back on those, wait to hear Mr. Hall's evidence, and then you can perhaps answer some questions if there are legal implications to that. There is one question I would just like you, for the benefit of those who don't have any legal training, including myself, explaining exactly what a lacuna is.
Yeah.
Gap.
It sounds like a beach in California to a lot of people.
No,
It's a gap.
the gap. What I'm saying is I think there's something missing from the strategic objectives, and that overall the PDP would be better off for addressing that gap.
Okay, thank you. I'll just see if the other commissioners have any questions of your legal submissions.
Yeah, it's just a detail really. Obviously, you're embracing some quite big issues, but just towards the end of your submission there at 43, at paragraph 43, that addition that you're seeking would be made to that general approach chapter. Do you think that I mean, you're talking about clarifying things, so it seems to confuse things more than clarify it.
To me, it certainly does clarify it, but I'd be interested in engaging with you on why you think that, through the chair, why that would add confusion or a lack of clarity.
I would have thought it'd be better to remove the whole paragraph and rewrite it that embraces both the points made and what's already there and what you're suggesting should be there. I don't know, I'm not the author of the plan, but it just seems that would be, I think that it introduces an element of confusion more than clarifies things.
So certainly the intention is to try and address the two issues. If I think what you're saying is that perhaps a rewrite of the whole provision to sort of incorporate the two might be clearer. Look, that's something that we could give some attention to, the detailed drafting. Try to work with the plan as much as possible rather than sort of substantially rewriting. But if it's a matter of sort of the intention to capture two, but be clearer than this.
Well, I mean, just what you could discuss with Mr. Hall. I mean, that just seems to me to be the case, and having a look at it might be something you have to think about.
It could possibly, I understand where you're coming from, and it could possibly be streamlined.
Yeah, that's all. Thanks.
Well, just to add to that, I mean, is the issue whether is what you're trying to clarify that the overlay extent and the control is limited to that part?
That's correct. And also to just be aware that the top level talks about, zone precinct controls, which tends to be read as rules when you go through and interpret the plan, but actually it's the entire provisions of an overlay will contain objectives and policies that are also relevant to that application. So being clear that only they apply in relation to the mapped area of overlay.
So you're concerned that there's a clear statement about the rule, but not necessarily the mapping.
So that's right, or that there's a reference to, reference to a proportion or percentage of the site. That doesn't really accord with mapping. And my sort of general reading of a provision, that's sort of talking about something that applies to a proportion, but we're actually talking about applying to a specific part that's mapped. And so there is that sort of potential for what does that mean, and the intention of the amendment to try and clarify. Yes, you might be talking about rules, you might be talking about a rule that only applies to a proportion, but we're saying in relation to the overlays, it's to be very clear that the overlays apply to where they're mapped, and that means that the objective policies and rules that go with that overlay apply only to that area.
Yeah, okay. Well, I did say I was going to hear from Mr. Hall, but I'll jump in now anyway. I mean, could it be just clarified by putting the word mapping somewhere at the front of that sentence, something like where mapping or a rule, so that it's clear that mapping and the rule relates to the overlay. Anyway, I'll throw that out there. I get where Commissioner Watson is coming from. Sometimes in a clarify, you end up muddling.
Yeah, certainly not the desired outcome. Yeah, I think that amendment would also need to have something in it to capture, the provisions and to be broad. Now, I haven't considered what that might do in terms of other zone and precinct controls elsewhere in the plan. It's presumably the council office have drafted it with sort of something in mind there. So I haven't thought about it broadly, but in terms of in relation to overlays, that to me seems quite sensible. I do think that it is probably more of a planning matter, so I'll just hedge my bets on that, having not discussed it with Mr. Hall.
So I think we'll probably hear from Mr. Hall, at least telegraphing that issue for you.
Just a clarification of a couple of points. Under your paragraph 3, you refer to non-primary production activities. And then in 3(4)(c), you refer to overlays. I'll probably get some clarification of what you refer to an overlay, but that'll come out in the planning, I think. So I'll leave it to that point. But non-primary activities, we're talking about a raw production zoning. We're seeing what do you describe as not economically viable?
So that is something which we're going to have to defer to later hearings on when we actually talk about sort of zoning and the land use. That's something that's sort of an intention to call some evidence on and discuss. And I know that Mr. Hall can probably talk to that more broadly than I can in terms of a couple of examples.
Yeah, I guess that's specific. I'm talking about, we're talking rural production. We have seen land use change, pastoral grown trees, farming livestock versus carbon. So this could be actually more economically viable with the trees that are planted than it was under a pastoral situation.
It's a useful point and appreciate you raising it. I probably can't take it further in this hearing, but we'll come back to.
I think that Councillor McNally's my question was both referring to page 19 of the planning evidence, which refers to the land cover of rural production zone land for both agriculture and horticulture, and then also on page 5, the submitter's position about the term could not really meet the level of economically viable carbon reduction. So I also had queries around how that was defined, and I think the other matters have already been answered or questioned. Thank you.
The reduction question, I'll probably just indicate it applies differently in relation to each of the properties, given their different site sizes and the different vegetation cover and site specific factors. So it is something that we have flagged that we will need to address later on, and it's certainly on our radar, but it's not one that we're ready to do a particularly deep dive in for this high level strategic.
Okay, I think on that basis, we'll now turn to you, Mr.
Thank you very much. I probably should have just introduced myself a little bit more for the panel members who might not know me. So I am a director of People Hall Planning Limited, which is my own consultancy. I finished in 2019. Prior to that, I was a director and partner of Offermiscal Limited. I'm based in Auckland, as I mentioned. And I've undertaken consulting work throughout the country, including a number of plan reviews, the Auckland Unitary Plan, Hamilton District Plan, Waikato District Plan, the New Plymouth District Plan, which there was quite a bit of material on strategic directions on, as I recall, and recently the Thames Coromandel District Plan. So I have extensive experience in providing planning advice and preparing resources and applications throughout the country, including in relation to, as Ferris mentioned, coastal residential lifestyle development with conservation gains. And I've listed in my evidence there the examples of those, including a number within the district here. I was involved in the previous plan, the Far North District Plan review process, and presented evidence at the Environment Court on subdivision management plan provisions in 2005. So that remains a topic of keen interest to me throughout this process as well. So it's just a little bit more by way of introduction. But if I just jump into that overlay question first, and you have my evidence in front of me, and that deals with the question of where sites are subject to multiple overlays. And I proposed that new clause that where an overlay is shown on the planning maps, the overlay provisions only apply to that portion of the site covered by the overlay. Now that might be self-evident, and what it means is that if you have a properties are cadastrally based with boundaries, overlays follow geographic features. So more often than not, you'll get the property split by an overlay. It's simply trying to say that if you are doing something on that part of the property not covered by an overlay, then you're not subject to its provisions. Now, again, that might be entirely self-evident, but my experience is that it's better to have self-evident things written in the plan rather than not. There is an alternative interpretation that could be taken where a property is subject to an overlay and the property as a whole is subject to the provisions of that overlay, and I have seen that alternative interpretation. So I did draft that additional wording into the part of the plan, but those two sections which were discussed earlier with Ms. Beres, so they're dealing with two quite different things, concepts, and I accept it could be probably turned around, because the first part I think I've added is probably the more important one, which sort of states the obvious, that mapped overlays only apply, the provisions of mapped overlays only apply to that property, part of the property where they apply. The next part, as included and referred to in the survey report, is more to do where a rule applies by way of percentage to an overlay. It's a different concept. And I think, as the point I just emphasise, is that I've deliberately used the word provision. So when you're applying an overlay, you are thinking about its objectives and policies and rules, not just the rules. And that's another important concept also. So I think it is important to have that those words about the application of overlays. And again, that might be, so it might risk stating the obvious that they only apply where they apply, but I think it's important to state that obvious. I'm happy to sort of take questions on it as we go.
Relies pretty much on things being mapped correctly too, doesn't it? I mean, you don't want to end up at a consent hearing arguing about the ridge line runs through the site here and the mapping's been done incorrectly, like most of the sites of special significance around the country. The whole thing becomes a farce, so you'd have to be confident that the mapping was being done correctly.
And that no doubt will be the topic, or it is the topic of a number of submissions, I think, to that next hearing 4, I think. But I mean, I think with my experience with modern GIS mapping, it's easily available to put that as a layer down and see exactly where the overlay falls in relation to a piece of land. So it's quite easily covered.
It might come back and bite you, but that's fine.
Oh, well, no, I mean, it's all about clarity. So I think, as I say, it is just simply seeking the clarification that the counter view doesn't apply, that, where you have an overlay applying to a part of the property, then the provisions that are overlay don't apply to the property as a whole, would be the way to express it in the negative, or the alternative, I suppose.
I appreciate it. No, that's fine, thanks.
So that probably deals with that first part, and it's covered in my evidence. And then I presented also in my evidence the points on the strategic objectives in relation to the rural environment and also environmental prosperity. And so the rural environment, I suppose, like all such chapters, it starts off, and it says, in this case, it sets the overarching direction for the district's rural environment. So that's not just the rural production zone land, it's the rural environment as a whole, including the rural lifestyle settlement zones, etc. So the rural, as I said in my evidence, the rural environment is therefore a broad church. It has rural production as we know it. It also has a much more fine-grained subdivision pattern in rural lifestyle areas around the district. And I've referred there to the Section 32A report prepared for the rural chapter, which sets out some key statistics for the rural environment. For example, the number of parcels that are smaller than what might be normally regarded as a productive unit. 68% of parcels in the rural environment are less than 8 hectares in size. So 8 hectares in the 32A report is referred to as the bare minimum rural production. Now that will be debatable, and there'll be further evidence on that, but just as a statistic. And then 57% of the lots are less than 4 hectares in size. So I think that points to the what was referred to, the gap in that particular strategic objectives. It has a strategic objective which talks about headed rural environment, and it purports to be the overarching direction for the district's rural environment. But then it only has 2 strategic objectives, and the first one is about preserving high productive land, and the other one is about protecting rural production. And I absolutely agree with both of those objectives and consider them to be important objectives. However, I believe there's a gap in that it fails to cover the balance of activities that happen in the rural environment. And the examples are rural residential subdivision, tourism, education, rural industry, contractors, yards, conservation, recreation. They're all things that happen in the rural environment. And so I proposed in my evidence third objectives, that the importance of non-primary production activities in the rural environment, social, economic, cultural well-being of the district is recognised and provided for. So that's the basis of that particular objective, which is sought there. And then turning to environmental prosperity, which is the other strategic objective set, and in particular the discussion about the need to also recognise restoration in objective 5. And again, so objective 5 talks about the natural character of the coastal environment and outstanding natural features and landscapes are managed to ensure their long-term protection for future generations. And I've emphasised in my evidence that policy 13 of the New Zealand Coastal Policy Statement relates to preservation of the natural character. 14 seeks to promote the restoration and rehabilitation of the natural character of the coastal environment. And so the term protection as drafted does not capture this important restoration outcome, which I believe is important. And so if I think about what those words mean separately, if preservation focuses on protecting, preventing from ongoing degradation, for example, then restoration seeks to improve and enhance a particular environment. So they're 2 separate concepts there. And to put that into sort of terms of the submitters, one of the submitters' properties, Ormerino, is an example of that, where the land was first restored through extensive native planting, so it's a restoration effort, and then it was protected through ongoing predator control and imposition of covenants limiting further subdivision opportunities. And so it's a fairly simple change to that objective sought there to include recognition of the strategic restoration also. And where is that going? It ultimately, I think, as I signalled earlier, will become important in later chapters. And for example, the management plan subdivision, which seeks outstanding environmental outcomes in exchange for subdivision potential, and restoration is a key concept to that. So this is sort of signal why we are quite focused on that restoration objective at this stage. I didn't include my evidence, but because it wasn't a particular use, but I did review the Northland Regional Policy Statement. And I just touch on what I found there. So it wasn't used, it didn't provide particular guidance on what we're talking about today, but there's some concepts there I'll just point to which may be valuable. As is normal for such documents, there's objectives on not having incompatible land uses. There's the policy references 5.1.1 of the Regional Policy Statement on incompatible land uses. And also not to reduce the potential for soil-based prime production on land, highly versatile soils. And so the Regional Policy Statement focuses squarely on highly versatile soils. That's designed in as land use capability 1, 2, and 3. The properties that of my clients aren't land use classification 1, 2, and 3. They tend to be 6 and 7 with some pockets of 4. So just to sort of get a sense for that. That protection of land use capability 1 through 2 and 3 aligns, even though it predated it, but generally aligns with the national policy statement also on highly productive land, which focuses on those land use classifications. There is a appendix 2 to the Northern Regional Policy Statement that sets out regional development and design guidelines, and they're not particularly strongly directive to what we're talking about. So there's no particular direction, for example, for non-primary production uses in rural areas. It does have material that seeks to maintain and improve outstanding landscapes and natural character, and also improving, enhancing Indigenous biodiversity. So there's no strong regional policy direction on non-primary uses within rural areas. I thought I just should cover that because I did refer to that in preparing my evidence, but didn't cover it. So that's a summary of my evidence. Thank you, and happy to take any questions.
Okay, thank you. Just on that matter of highly productive land, you say none of your clients' land is highly productive, in reference to LUC classes 1, 2, and 3. Is it included, notwithstanding, in any of the interim mapping, any of the properties, or are they outside of the interim mapping?
They're outside the interim.
We know that the mapping can be a little bit fuzzy and incorrect. And it may be that you've done analysis, but you may still be mapped. So you're confirming that it's not mapped at all.
Correct.
With regards to the overlay provision, I think you're just trying to avoid an unintended consequence, it seems to be. I just want to make it absolutely clear what the unintended consequence is that you're seeking to avoid by those amendments.
The unintended consequence would be that the overlay provisions are applied to a property as a whole, where they're only applied to part of a property. And what that might look like, for example, in a coastal environment, you might have an outstanding landscape overlay which applies along the coastal fringe. Now that's properly where it applies, and its objectives and policies. Someone doing something several kilometres inland from that on another part of the property isn't subject to those provisions. That's the unintended consequences, trying to avoid.
And I think you were saying that you want to make sure that the objectives and policies as well as the rules are in that same.
That's right. So in my wording, I've used the RMA to provisions rather than rules. And provisions captures objectives, policies, and rules.
Thank you. This question of non-primary production activities, I certainly understand where you're coming from in terms of rural residential activities or enhancement planting, on properties that aren't intended or potentially viable for rural production. But I'm just sort of wondering about the way that you've termed it, non-primary production activities. That seems to me to be quite a wide subset. But what you described was actually quite a narrow frame of activity, tourism, education. And I'm assuming probably meaning rural related to education. I wouldn't want to put a university in there, but someone could read an objective like that and go, oh, I could put a university there. And is it tourism, rural residential, education,
conservation,
and conservation,
rural industry.
But potentially there could be quite a lot of other activities which are non-rural, which might provide the opportunity to establish on cheaper land. Might have some commercial activities, retail, possibly industrial. Maybe unlikely. But I'm just sort of wondering, if we were minded to include a non-primary production activities provision, whether that could be narrowed a bit so that it doesn't provide encouragement to a lot of other activities which are non-production based that you wouldn't want to be established there.
I suppose yes. The answer is yes, and the planning principle, I suppose, is that those activities which derive particular benefit from a rural location.
Yes,
is one way to think about that.
yeah, that's right. So tying a number of non-primary activities that have a, you could almost say there'll be some activities that could only be located in the environment, but aren't primary production based. And that's possibly your rural sport activities.
Rural industry, for example.
Yeah, rural industry type things. Yeah, so I was just wondering whether you might want to have a think about whether you could potentially frame that a little bit narrower. Because if you have this strategic direction, you know, which some people are calling an engine room, and then you say in that strategic direction, non-production based activities, that could send a flag to others.
And I know it's a case of sort of working up and down the plan a little, but the lower order part of the plan gives direction on that already, you know, with the range of activities that are actually provided for in the rural zones and the subdivision chapters, for example. So I understand what you're saying.
So you sort of almost half offered up a clarification then. I'd just like to write it down. So you remember what you just said to me previously.
I was saying that the lower order parts of the plans are the rural.
No, it was when you said before, you said you talked about non-production activities that had a reason to.
That derive particular benefit from a rural application. Tourism is a case in point. Conservation.
You could almost say direct benefit, couldn't you?
And you know, I would count on that limited rural lifestyle opportunities because they are provided for in the lower parts of the plan, because that is the reason the people are there, and that is the reason that typically the conservation outcomes can be implemented in the rural environment.
Is it a case for asking the submitter to come back with a suggestion on that as part of your submission, as part of your evidence now, that just respond to the questions from the panel, that you present the following clause that might address the questions?
I'd be happy to do that. It's difficult to draft on the hoof, so.
You know, that's why I completely agree with Commissioner Watson. I was probably going to allow, I mean, we won't be closing this hearing until we hear from council officers, and we're going to be giving them 2 weeks to respond to the evidence that they've heard. So if you were minded to suggest something, you could submit it to us, you know, immediately after the evidence, and then council officers could then consider that in their reply.
Chair, is primary production specifically identified and outlined in the plan, both existing and proposed?
It's defined, as I remember.
Yes, that's defined.
Does that eliminate the problem we've got with non-primary?
I wouldn't have thought so, because I think non-primary is too open-ended as well.
Yes. I mean, I sort of jotted down some possible words too. So non-rural activities that are suitable or compatible within a rural environment, or recognising that in some circumstances non-rural activities are appropriate.
I guess my point was
Because they can't be located elsewhere. It's something.
I agree on the compatibility part of it too is another feature of them.
Yes.
They have to be compatible with primary production, otherwise they start to run head against the protecting primary production objective.
Several got any other questions? No, I think I've sort of covered my questions. You got any questions?
Mr. Chair, just a question relating to the terms of restoration and enhancements, both referred to in the evidence from legal counsel for the NZCPS and the regional policy statement. The term in your evidence, Mr. Hall, on page 19, the term broader church of the rural environment. And we've had some questions about that relating to the definition of non-primary activity. I think as well, the question I have is about restoration and enhancements and allowing for our plan to have opportunities for further restoration and enhancement, so that people are encouraged to have those activities within the fund referred to conservation. Can you talk further about the terms restoration and enhancement in the context of what you're requesting to the changes for the strategic chapter?
Certainly. There's a couple of concepts there, but I'm not an ecologist, but I spend enough time with them. One is that areas, for example, of native vegetation, which would appear to be protected, fenced in place, may in fact be going backwards. So without pest and predator control and pests, goats, pigs, and what have you, that deal through the next generation of plants and ongoing possum control and that type of thing. That particular piece of bush might be going backwards. So protection as a concept isn't just about fencing; it's about active management. So that's part of the protection part. Enhancement examples of that would be where there is already a degraded landscape or piece of land, and a lot of coastal farmland is very suited to farming, but very highly suited to restoration. And so that's turning around an existing degraded a natural character, and through planting and then ongoing protection, ensuring that it is restored to something closer to what it might have been originally. So they are, as I say, that notion of protection and restoration are two separate concepts. Again, why is that important to submitters in this case? It's because, again, pointing to the opportunities through the subdivision chapter, and what that is about is that it will typically take a significant injection of capital into a piece of land to do the fencing, to do the planting, to do the ongoing pest and predator control. Thereafter, there's also ongoing costs, and through appropriate subdivision, you can establish a community of care, as the word that is often used. And so these are landowners that will continue to pay for and fund the ongoing protection of that area which has been restored. So those are the sort of broad concepts that, as I say, I think protection is covered at a strategic level, but where there is a gap is the restoration aspect, and restoration is about taking something degraded and turning it around to something more akin to what it used to be. And both of those concepts are recognised in the separately in the New Zealand Coastal Policy Statement, separate policies on them.
Just a quick question. All of the sites that your applicants have, that you've put speaking for, what is the current zoning for them now, and what is the proposed zoning?
They are, for the main, well, they're split zoned actually, so they have a coastal zone and a rural production zone, the current one. So yeah, split zoned for the main. Of course, now the coastal zone is gone, so they are all now zoned rural production. And they have overlays, a coastal overlay, typically an outstanding landscape, some high natural character overlays. Yeah, so again, sort of going to that they all in their own way demonstrate differently that concept that they are still rural environment, but they are not production, and well, not exclusive, they're not all production in the formal sense of the word.
I just have one more sort of concluding question, and that's related to the use of the restoration provision. I certainly understand why, and it's obviously it's quite good to hear large landowners wanting to engage in restoration, taking something that doesn't have high landscape, environmental, ecological value, and giving it that status. That's got to be amended. It seems to me that councils have had a bit of a struggle because restoration is a deliberate act that is often offered rather than directed as a result of a resource consent or other action. And in that sense, words like enhance have often been challenged in district plans because you can't require enhancement, and in that sense, restoration, unless you're mitigating an adverse effect or offsetting or something. Is there an issue that we should be concerned with when we have like this word restoration, the presumption of a willing act as opposed to a directed one? That's possibly a legal question as much as anyone.
Because there's certainly reasonably new parts of the Act that deal with positive effects.
Yeah.
I think I'm thinking on the hoof a little bit, but if you look very broadly at what district plans to achieve, and I've actually addressed that part that I didn't go over in my legal submissions about integrated management and the functions of territorial authorities, there is a real broad scope, and it's a broad objective of managing land use within the district. Now, there's different things that can be done to achieve that in terms of the planning policies and the methods that are used. And methods can be, they can be a stick in the sense of you must not develop past this level, but it's also quite common to use planning tools that are about incentivizing certain outcomes or certain trade-offs. You see it in an urban context with things like bonus height provisions or GFA provisions for certain public amenities and that sort of thing. And so I don't think that there's necessarily any difficulty, particularly at a high strategic level in the district plan, to be including in there something that's actually about trying to incentivize the right outcomes. How that plays out, I think, is a good point. You probably want to articulate that further in the individual chapters of the district plan and what that is to look like and what that incentivization and what that encouragement looks like. But I don't think there's any difficulty including the concept at a high level, recognising that you'll need to flesh that out. But having it at that high level, it does say, we're going to think about those subsequent chapters in light of that it's there in the first place, and I think that's positive. So I don't see any difficulty with that, but I do think it'll need some further articulation in the subordinate chapters.
Yes, because I mean, submissions that most of things like restoration and particularly imposing a duty of restoration, unless it's directly associated with remedying an adverse effect. So I suppose we're sort of mindful of the other side of the coin that we have to consider. And if you are going to throw a word like restoration and right at the very front of the chapter, do we need to consider that? Do we need to acknowledge that that is, in a sense, a voluntary act?
I'm not sure how voluntary it is in some respects would be the other point I'd make. I think that the New Zealand statement, which is at the highest level of planning policy, is quite directive about the need to provide it. So I mean, yes, I've talked about it in terms of it being a voluntary incentivizing.
I think you've quoted the NZCPS and their references to restoration in there. So is that where we would look?
That's where you'd look, particularly objective 2 and policy 14. So you sort of have policy 13 and 15 that deal with the protection aspects, and then 14 separately. I've not actually quoted it in full. It's quite an extensive provision. I just sort of highlighted the key parts that were relevant to save some paper there. But I did add sort of the emphasis throughout to just try and show that there really is a theme of encouraging that restoration. And you see it with, I mean, the language isn't always about restoration. You see it throughout the policy documents in terms of enhancements and improvements and that sort of language. I guess the point we're trying to make is it is a distinct concept. It is provided for at a very high national level in relation to coastal environments. I don't see a difficulty in providing for it, even if it has to be voluntary, sort of to enable that incentivization. But I do think you'll at least stand by that it will need to be fleshed out what that means.
And your analysis of the regional policy statement. Did you see the word restoration in there as well?
The words I saw were,
And could you just direct us maybe to a
Yes.
section or a policy, maybe that?
yeah, appendix 2 to the regional policy statement sets out the regional development and design guidelines. It sort of sets out a long list of directions for regional development. And then there's 2 in there. Matter L seeks to maintain or improve outstanding landscape and natural character values.
Did you say matter L?
Yes, L.
Alpha length.
And then matter N for Mary seeks to protect significant ecological areas and species, and where possible, enhance Indigenous biodiversity. So the words it uses are improve and enhance. I think I've simply gone with a higher up the chain to the New Zealand Coastal Policy Statement.
Yeah, yes, I mean, I was sort of grouping restoration and that sort of general group of.
So Mr. Hall hadn't addressed that in his written evidence, but if you'd like a reference, I have quoted the same paragraphs in my legal submissions, and that's paragraph 21. And this refers to those provisions that Mr. Hall just discussed.
Because I think what we're clearly considering is if protect is about something that has value and you want to maintain it or make it, or even make it better. Whereas what you're talking about is taking something degraded and returning it to a status that previously existed, or giving it a status that it never has had. Okay, well, I haven't got any further questions. Any other questions?
Just got one that refers to paragraph 4, and I asked it earlier, but now I've looked at it again. A, you say introduce a new strategic activity as a strategic direction chapter, and you refer specifically to non-priority activities, but more importantly, the contribution they made to the wellbeing of the district. That's pretty broad. And then after that, you use B as recognise the importance of restoration, and then C, clarify. So really, it's only that first strategic, they want to make strategic direction. So there's 2 things there. One is the non-primary production, which has caused us a bit of questioning already. And I think I get what you're trying to do. I'm not sure that we just need to work out how to word that more specifically if it's going to be at that high level.
Yeah, and I'm happy to provide some additional wording in response to the questions today.
Thank you. Do you want an indicative timeframe as when you'd like to, when you could provide that?
This week.
Okay, that sounds fine. And obviously just submit it to and council officers, obviously we're interested in what you have to say about this in response to the evidence, but I think we're gonna leave it till the end of all the evidence on Wednesday. We may come to you if we want some clarification. We'll be able to respond at the end. Well, thanks very much for your legal submissions and evidence, Mr.
Thank you very much.
Okay, this was related over 12:15. We've got no submission.
We've got the mix.
Are they ready to go now?
They've asked for half an hour. They are ready to go now. Would like them to go now.
I think we should go. We'll box on and see.
The box on.
So we go to our next submitter, which is Audrey Campbell-Freer. So we have representing Audrey Campbell-Freer, Sarah Shaw and Melissa.
Good morning, panel. So I am Sarah Shaw. Apologies for the people. I am counsel for Ms. Campbell-Freer, and to my left is Melissa McGrath. We'll be addressing you for other submitters today as well. So I apologise that my legal submissions were not completed on Friday last week. I was unwell for all of last week, but I have provided those electronically. They don't have a hyperlinked case links in them, but I can refile those as an amended copy with hyperlinks for those cases for you. Apologies, I arrived, I think, just a couple of minutes too late this morning to hear the exchange about Ms. Campbell-Frere's submission having been missed from this topic. I understand Ms. Campbell-Frere is behind me, and I understand that there is going to be an addendum.
So it's you to say. So perhaps we'll just Ms. Webster updated us on some submissions that had been missed, and we've accepted those.
Okay. So
I think we as a procedural matter at the start of the hearing, so we recognise the submission.
Yes, thank you. So just I will take you through the legal submissions. You haven't had an opportunity to pre-read them. I don't need to read them out to you. We'll just skim across the top of them. So Ms. Campbell-Frere is a primary submitter and also a further submitter on this plan. She owns property, she owns multiple properties, but the one that the submission are primarily concerned with is southwest of the Kaikohe township on Kaikohe Road. And for those who are familiar with the area, if you think Makana and the pack house, that sort of stretch of Kaikohe Road is the approximate location. Road numbers don't help much, but a landmark is.
I was going to say, I mean, if I entered it into Google Maps, would I find it?
So Kerry Berries is the front of the property, which is basically immediately adjacent to Makana. I haven't given you the details of the property because the submissions are not site specific. They are all of the parts of the submission are more strategic. But in terms of where her main property is, it's located on that section of Kaikohe Road. And if you find Kerry Berries, that is the front of the property. So the primary submission addresses 4 things, and those are, loosely speaking, deleting the horticulture zone, reviewing the commercial zones, addressing a hierarchy of centres, rezoning the Kaikohe Fringe to enable commercial activities, and reviewing rural residential zoning west of Kaikohe Road. And it's the first 3 of those, and in fact primarily the first 2, that are relevant to the strategic direction hearing. And Ms. McGrath has filed expert planning evidence for the hearing. In terms of preliminary matters, the summarising of submissions and the electronic portal for filing further submissions, Spoken, have caused some unexpected issues. And so I don't need to take you through paragraph 1.7 because you're aware the summary shouldn't pick up the strategic direction component of the submission, but we are here, and the plan going forward is to attend those hearings where the submitter thinks that they need to be, and to alert you in advance to that. So at paragraph 8, just indicating that there are some inefficiencies for submitters when they've been missed or mis-summarised, but we can deal with that. So at paragraph 1.9, the 42A report appendix had picked up 4 further submissions made by Ms. Campbell-Frere as being relevant to this hearing. But when I looked into those, I think there has been a significant issue with the Spoken process for further submissions. I've set it out for you here, not for you to deal with, but so that you're aware of it. The further submitter number is FS172, and when those were entered into Spoken, they got a 3-digit suffix on them. So as you responded to individual submissions, it would allocate 001, 002 as you were going through. The numbers that were given in the 42A report for Ms. Campbell-Frere, as for example, the one that the reporting officer thought was responding to the McDonald's primary submission, that further submission suffix number was not the same as the one in my records of the document that I lodged. So those suffix numbers, the 001 component, something has gone awry with those. I don't know if it's only in Ms. Campbell-Frere's or if it's more widespread. The second bullet point there, when I looked into this, my record of the further submission that was lodged electronically is numbered from 001 to 0418. So to my records, I filed 418 points of further submission. the council's red text on the front page records that there were further submission 0.001 to 416. So that was an immediate flag that something wasn't lining up. And then actually when I looked into the spoken automatic numbering of each entry, there were multiples. So there are several 0.417s on that further submission. Something has gone wrong with the numbering. And as a consequence of that, at my paragraph 1.10, those numbering errors seem to have resulted in the council is working from a different list of further submission points than what certainly what Ms Campbell-Freer has, both in my records, and also I checked that the council's copy is the same as mine. So I don't know where the errors have arisen. I leave it that I will take this up directly with the council. We'll try and work out what's happened and how to address it going forward. But if you do get any confusion with people in terms of their further submitter number, as I say, it may be isolated, but we will do our best to sort that out.
Well, it might be something that we could tidy up when the council officers do their written response to the evidence.
Yes, and it may be that it's an isolated incident. It might be only this further submission, but for example, it makes it much more complicated that there are multiple further submission points that have the number 417 allocated against them, because clearly the numbering has shifted. The ones that the reporting officer included in the appendix to this report, some of them were out by 1 digit, some of them were out by 5 or 6, so it doesn't seem to be consistent, but we will sort that out. They must have a system at their end that we can match it up somehow. So I just deal first with the scope of the submission, because this submission was missed out of the 42A. And so for completeness, I have addressed the question about whether this submission, whether the evidence that Ms McGrath is giving was fairly and reasonably raised in the submission. So at 111 there, I'm just saying that due to it not being coded, I'll deal with this first. And while much of the case law on scope focuses on whether it's sufficient on a plan change, here obviously you're dealing with a full plan. It's pretty much everything on the table, and it's more a question of when someone is asking for specific relief in their evidence, particularly when they've got expert evidence, was that reasonably and fairly raised in the submission? So this is the part that I will make sure I hyperlink, and I'll refile the submissions for you. Justice Fata, in terms of the Auckland plan, the Auckland Rentry Plan, reviewed 25 years of cases on this point and came up with a really quite useful summary of what the considerations are. So the first bullet point there is whether any amendment raised it is reasonably and fairly raised in submissions. That plan making is participatory and it should not be bound by formality. You need to approach it in a realistic and workable fashion. It's an issue of substance over form. The workable approach requires a decision maker to take into account the whole relief package detailed in the submission. Amendments are not limited to the express words in a submission. If it's sufficient, if amendment can be said to be a foreseeable consequence submission raised. Once you get to an appeal, Rule 14.2 of the Act requires only that the person referred to a provision or matter in the submission. The legislation doesn't talk about that it was the relief sought. It says that it was referred to. And ultimately, whether any amendment was reasonably raised is a question of procedural fairness to the public and to the submitter. So at paragraph 114, in that first theme of Ms Campbell-Freer's submission, talking about the horticulture zone, her reasons included a reference in those 2 bullet points to strategic direction. And at paragraph 115, in the second theme, where she was addressing the hierarchy of centres, again, 2 bullet points there giving you quotes from the submission that raised directly issues of strategic direction. So in my submission, taking a realistic and workable approach to the whole relief package that was stated in the submission, it is clear that the deficiencies or omissions that are now being discussed in Ms McGrath's evidence were found in the body of the submission, and therefore in my submission the amendments and the evidence now filed were reasonably and fairly raised in that submission. So turning to the planning evidence, I have not attempted to summarise it for you. You have read it. Ms McGrath has prepared detailed evidence and a section 32AA analysis focused on the strategic direction section. She has identified the critical importance of this section and that the proposed plan currently fails to meet the mandatory direction of the national planning standards because the strategic direction section fails to adequately outline and address the resource management matters. Ms. Beresford addressed a similar issue in her legal submissions to you and set out those statutory provisions and the links between plan making parts of the RMA and the national planning standards sitting there as a mandatory component of the process. So Ms. McGrath pointed that failure to include strategic direction policies or to adequately demonstrate that the required policies are in fact located in other chapters fails to again meet the national planning standards and also section 32 obligations, and that the need for policies in the strategic direction section to address zoning and centres hierarchy, because those apply across zones and across the district. So they're not something that you can find policy for in a particular zone, because the whole point is that the allocation of zoning frameworks and zoning hierarchies, they sit above and everything else falls below them. So the third bullet point there, the failure in the 42A report to respond to submissions seeking strategic direction, establishing a hierarchy of centres and the planning importance of such a hierarchy in the proposed district plan. Failure to assess the extent to which the strategic direction gives effect to the NPs on highly productive land and the planning importance of a rural zoning framework, and the report error in considering future changes to national policy statements that have been flagged by an incoming government, which is contrary to section 74, which requires the council to prepare the plan in accordance with the national policy statements and national planning standards as they exist. Now, of course, at that last bullet point, if the point at which the panel makes the decisions, those policy documents have changed, then you may need fresh evidence on that. But at the moment, the fact that the government has forecast that it intends to change policy statements, you can't do anything with that except watch for whether those arise. In my submission, if the point at which you make your decision, because there's clear law on this for the section 104 decisions, at the point that you make your decision, you have to apply the documents as they apply, but you can't forecast what those might be until they are changed. And just, I've concluded here.
Sorry, just to interrupt there, because I think that's an interesting point. It's 43 reports flagged that there is change coming. And they're saying, I think they're saying we're not necessarily going to commit to an outcome with regards to understood that there is change coming, and we've got the Prime Minister saying don't do anything on the NPS for Indigenous biodiversity because we've got significant, and I think it's in a cabinet paper, and I know that changes to the NPS highly productive land is in a cabinet paper. So it's sort of stated government policy. And I suppose whether you apply it under section 104 1B, obviously you can't. But in terms of a plan making process, we should be acknowledging what is pretty much a clear government direction. Not to do work that we're about to undo.
I'll pull it up, may not have the same, because there's often the catch-all when people are making one of the decisions that they'll use 1C and just chuck it under another relevant matter. If section 74 for plan making doesn't have that same flexibility in it, then the section requires the plan making to be undertaken in accordance with the listed documents. And so one thing I've noted with the shifting resource management landscape over the past 6 months is that there has been a lot of talk and some commitment, as you've indicated, to change that will come. But in terms of section 74(1), the Territorial Authority must prepare and change the district plan in accordance with, so very directive language, and that is at EA, a national policy statement, New Zealand Coastal Policy Statement, and a national planning standard. So those are the standards and the policy statements as they're gazetted. In addition, so put 2 brings in addition, shall have regard to a proposed regional policy statement, a proposed regional plan. What's this relevant planning document? No.
It just, I mean,
There's no equivalent of section 104(1)(c) of a bucket of any other relevant matter that, the point is that if those changes are made to those documents before you make your decisions, then you will need to reassess your decision making in light of the documents as they exist at the point you make the decision. But the caution is not to place too much weight on that until it happens, because at the moment the documents say what they say, and even if there are cabinet papers committing to future changes, until such point as those documents actually supersede the current ones.
and I presume they must go through a consultation process, and there is assumption that they may change.
Well, there might be a select committee process of a couple of days.
Yes, and I don't know if you missed caught my opening statement before the first submitter. And that is that as a panel, we've committed to releasing one report at the end.
Yes.
We are going to be undertaking sort of what we're loosely terming interim deliberations at the end of each topic. And we'll sort of consolidate our thinking, but we know that we may have to return to those interim deliberations when we hear other chapters. Obviously, they may change our thinking. But also too, is that, we may be operating under a completely different legislation by the time we issue that report. And so there may need to be some significant adjustment to things that we've already heard, and may need to rehear some things.
I would anticipate that the transitional provisions for any significant amendment to the RMA or any replacement of it, there are generally quite detailed transitional provisions, and they usually provide that if a process started, it has to be completed under the law as it was. And I know that on probably every second Environment Court hearing I have before Judge Smith, we have this little dance at the beginning of the hearing about, okay, but which version of the Act applied when consent was sought? What was the version of the Act that applied when this plan was notified? And actually, often practitioners have forgotten and have been for a number of years applying new provisions as they exist. And we all have to remind ourselves that we have to reset. What did the provisions say? So usually the transitional provisions actually lock you in that you have to complete under the law as it was when you started. But it's certainly something to be aware of as you say, move forward. I think interim deliberations is something that the panel has sensibly decided is the only way to manage the volume of material. But this leads into the wider issues that I had raised at the end here. Paragraph 120, Ms. McGrath has raised a particular concern about the 42A report recommending rejection submissions which seek additional commercial zones. So this is the hierarchy of centres, on the basis that a future technical assessment by the council will address housing and business capacity. In my submission, it's not in accordance with natural justice to reject submission based on an assessment which doesn't currently exist. And it is concerning that the council notified its plan and commenced its hearings when that fundamental technical assessment, which was presumably foundation to the 32 assessment, has not been undertaken. And I think that I'd just add at paragraph 120, it may be that the reporting officer intended that paragraph to read that those submissions should be held and should be reconsidered in the zoning topic, but the language used in the report is a recommendation to reject them. And I strongly draw that to your attention in terms of the appropriateness of rejecting a submission on the basis that a future hearing will bring new information. If those submissions need to be considered in light of that future information at a future topic, those submissions need to be in that topic so that submitters have an opportunity to pursue their submission. And at paragraph 121, to me, this strongly indicates that the panel may need to revisit the strategic direction hearing and in particular submissions seeking a hierarchy of centres and zoning policies after that technical assessment of housing and business capacity is completed. It's always really difficult with these full plan hearings to know, without reinventing the wheel, how to tackle the material, and you should in many ways start at the top and get the strategic direction and the policy drivers and the direction of travel clear. But when we have some fundamental missing information that won't be presented until a hearing in 6 months' time, how does the panel determine what that strategic direction is? Because we're not going to get that information. And at paragraph 122, how can strategic direction fulfil its national planning standards mandated function of setting out objectives and policies that address key strategic or significant matters for the district to guide decision making at a strategic level when fundamental assessment of how housing and business capacity is to be spatially accommodated has not been undertaken. So in conclusion, in my submission, Ms. Freer's submission reasonably and fairly raised omissions or deficiencies in the strategic direction section. That's how I say that Ms. McGrath's evidence is relevant to your hearing this topic. And I'll hand that to her to pick up in her planning evidence for you. I think we have a PowerPoint. Take you through.
Yes, thank you. I mean, we were scheduled to have a lunch break at 12:15.
We were the first submitter after the lunch break, so it depended whether you wanted. We only asked for a 15-minute planning assessment, and I think it would be even less than that on the basis of the slideshow. We're in your hands if you want.
Okay. But it may be that some people may need just a quick break. Are we okay? Are we all good?
Yeah, can help.
Okay. Well, in that case, we'll. What we'd like to do. Yes, we're going to make 5 minutes adjournment.
Okay, good.
So we're back from the adjournment. So Ms. McGrath, we're ready to hear your summary. I see you've got a PowerPoint presentation.
Yes, good afternoon, Commissioners. We find it sometimes helpful to have a presentation to run through and direct the summary of evidence. So I do just note my introduction of my statement, my experience and qualifications. I was a resident in Far North for many, many years, grew up here, went to school in Northland College in Kaikohe, so I am well versed with the district. And had the pleasure of working at Far North District Council for a number of years as a baby planner as well. So I have worked with the operative plan. So just, Ms. Shaw has identified the key points of the evidence before you. Again, it's a brief summary that is the strategic direction chapter is a very important chapter to the plan. I have had numerous experiences in consenting and private plan changes where a lot of the policy conversation and the decision making comes back to the strategic direction and the relationship between the chapters and the layers of the plan. A concern of the lack of policy in the strategic direction chapter, a centres hierarchy, zone framework, and the relationship between strategic direction and the national policy statement for highly productive land. We'll just take you through that. So, Commissioner, you noted that we're calling this the engine room of the plan, and it is the engine room. You've heard already today that the intention of this chapter is to sit over top and the policy and provisions fall underneath. It doesn't matter which chapter they're in the plan, they all should be filtering back and linking to the strategic direction. And so therefore, it's important to get it right. And for you to be able to make your decision making throughout these hearings, everything is linking back to that strategic direction, objectives and policies. So your consideration now has a long-term effect for the rest of your considerations and deliberations. In my evidence, I put to you that the strategic direction as proposed is flawed. In my opinion, it fails to meet the mandatory direction of the national planning standards, which is to adequately address the significant resource management matters for this district. And in my opinion, what is before you is somewhat lacking. And the key points that I have identified is the balance and trade-offs between conflicting matters at national, regional and local importance, the strategic direction for urban development and a centres hierarchy,
the strategic direction or policy support for the suite of rural zones that have been proposed, and you have heard some of that already this morning, and a lack of zone framework, including the purpose, direction, and zoning criteria for the zones that have been proposed. So, as notified, the strategic direction chapter does not include policies. And I note the National Planning Standards mandatory direction 7.1c states that if policies are to be included, they must be located in the strategic direction section unless those policies are better located in another more specific chapter. So the reporting planner has put to you that they are located in more specific chapters. But to me, that is unclear in what has been presented in the section 32 and the 42A. I haven't seen a logical framework of policy that makes it obvious that they are tied together, that there is a link between the objectives and the policies throughout the plan. And I put to you that there is a lack of integration between the objectives and policies in the chapters, and that suggests that section 32(1)(b) has not been met. The strategic direction with respect to management of effects within the rural and urban environments, zoning incentives hierarchy is not better located in the zone chapters as they apply across zone boundaries and across the district, and therefore they should be sitting in the strategic direction chapter and apply district-wide. Moving on to a centres hierarchy. Now, it's very odd to see a plan with only one commercial zone. I've done some research and I haven't seen one actually. And as notified, the proposed plan only identifies a mixed use zone. And I put to you that that is unusual, ineffective and inefficient. Establishing a hierarchy of centres assists to confirm the range of resource management issues, potential effects and responses to these, and they can be tailored to the different types of urban centres, which creates a more efficient and effective zoning method across the district. The section 32 evaluation, in my opinion, is incomplete. It provides an insufficient justification for the single zone approach. The section 42A report refers to assessments that are coming up, which Ms. Shaw referred to, and identifies that there is not a demand for alternative or multiple commercial zones. And I put to you that demand is not a sole justification nor a determination for a zoning framework. And in my opinion, there are multiple factors that should be taken into account when you're considering a zone framework. And those are primarily planning matters that should be considered. And I've listed in my evidence to you that the factors that could be considered that are relatively simple to council that could be used to establish a hierarchy for this district. So turning to a zone framework, the strategic direction, objectives and complete lack of policy are silent with respect to zoning criteria and outcomes across zones. And so therefore you do not have a zoning framework which has been established across the district, which the zones can logically be applied spatially. A zoning framework provides direction for consideration of resource consents, particularly non-complying out of zone activities, and for private plan changes seeking to rezone land. So this is a matter that moves beyond your considerations now, but for the future use of the plan and the implementation plan of the plan moving forward. Again, the section 32 evaluation does not provide justifications for the zones that have been identified and the criteria of the selection and distribution of zones. And in my opinion, that it's a lack of information that is before you and a flaw with the plan as it's been proposed. Furthermore, the section 32 evaluation does not consider options in the full range of zones put forward to councils under the National Planning Standards. And there is a large suite of them for commercial zones, and I have listed them in my evidence for you. And finally, turning to the strategic direction and the NPS HPL, already had a conversation about that's likely to change or is indicated to change. It's not yet before you. The section 42A report has not provided any recommendations with respect to this national planning standard. And in my opinion, that again is a failure. The objectives and policies of the proposed plan cannot contradict the NPS HPL. It is operative and it must be given effect to, and to not have alignment, in my opinion, fails Section 32. In my opinion, strategic direction objective SE rural environment, O2, objective 2 is inconsistent with the NPS HPL because it does not specify the purpose of protection for the use of land, which is land-based primary production. So therefore, I think there is an inconsistency between the higher order policy and the strategic direction as proposed. Again, I note that Ms. Campbell-Freer has opposed the horticulture zone in the proposed plan, and I have recommended that this, or I recommend that this zone be deleted as it fails to give effect to the NPS HPL. I also note, again for further consideration in future hearing, that as proposed, the definition of highly productive land in the proposed plan is contrary to the NPS HPL. And I note these, given the context, again, that strategic direction feeds down to all of the zones, all of the provisions, the zoning location, the spatial distribution should all be filtering back to and giving effect to the objectives that you are considering before you now. And if there's these flaws before you even start, then you're going to have serious concerns moving forward. So that, in summary, is a summary of my evidence before you.
Okay, thank you.
I think if it was a wrestling match, they'd probably call it a body slam. In terms of the presentation, given the criticisms, there are criticisms in terms of the way the plan's put together and the like, whether we agree or not, it's a different thing, but are we in a position where there's submissions that are sufficient for us to address those through the submissions process?
Sorry, can you expand on that?
Is there sufficient in submissions? You're obviously familiar with your submission, but also in other submissions. Is there enough in those for us to sort out the problems that you've put in front of us?
Yes, sir. I think there is, with quite a lot of work. I think that these problems could be solved with redrafting and consideration. And again, I'm always happy to work with the council planners and work to a solution. There's always a way forward. But again, I think it's something that probably needs to take stock and consider now before you move forward into the next hearings. I mean, as you heard from Ms. Shaw, there's some serious concerns with the delay of technical reports and parts of Ms. Campbell-Freer's submission being rejected at this point. It's quite big topics and matters for you to consider.
Now, how the council's relying on a housing assessment, a housing and business assessment coming forward, won't be completed until I think it was the middle of next year sort of style. Have you, either of you, come across in your legal and your planning experience any similar situations in terms of district plan considerations where, a significant topic like, future subdivision and housing around Kaikohe, for example, is held off while that sort of studies carried out and the proposed plans delayed?
In my submission, if it's important enough that it's driving rejection of submissions and or deferral of consideration until well into your hearing schedule, why was it not part of the Section 32 assessment? How was the spatial zoning assessment developed for this plan? So your specific question was about my experience of other plans. There is always sort of new and refreshed evidence that comes through for the hearing of submissions. There is an acknowledgement that it takes a long time to develop a plan, to put it out for a draft, to notify it. But the Section 32 analysis for this plan was somewhat thin for some of the big decisions like spatial allocation of zoning. And it appears that some of the significant background work is being done for whatever reason. I'm a pragmatist. Budgets are real things. Workflows are real things. You are where you are. But if there is a significant report on housing and business capacity, my question is the significant 32AA reassessment that will need to be done in terms of, but there are submissions before you that, and not just from Ms Campbell Freer, that seek hierarchy of centres, seek a zoning framework, seek that there is a much better description in the plan for how zoning has been allocated and on what basis. So not just in the strategic direction hearing, but also in the rezoning hearing, which is one of the last ones you'll come to. And as I've said, it's always a complication of these processes that rezoning is often one of the last hearings, but in fact, it means that for a submitter who has uncertainty, and they will until the point of the decision is released, they have to involve themselves in what their current zone is, what the zone is that they've sought as a replacement, what alternative zone they might actually be allocated by the panel. So they have to involve themselves in the preparation of various parts of the plan that may or may not impact on them. So I think it is unfortunate that that big piece of work didn't form part of the 32 and wasn't part of the preparation of the plan. You will receive it. It will have to inform the 42A reporting on the rezoning topic, and submitters will need to, it might be one of those things where the timing for 42A report and expert evidence might need looking at. If there's a significant new piece of work that the 42A report is relying, when will the submitters receive that? Will they have a fair and sufficient time to respond to it in their expert evidence in the timetable?
This issue is going to come up for us, as you say, a number of times, because there's a number of planners and lawyers that have addressed it and the like. I mean, putting the legal niceties aside of what we can do and what we can't do as a commission panel or whatever, one would think that you wouldn't hold up the rezoning, what rezonings need to be done in the Far North District when there's obviously parts of it that are an urgent need of attention. And I'm not giving evidence, but there might be a case that people say there's an urgent need for rezoning around Kaikohe. I mean, is there anything to stop the council sort of initiating a plan change at the present time in response to a variation in response to some of the submissions to address that in the interim?
Well, there's not, but the other thing is that people take matters into their own hands. I'm not so familiar with what's happening in Far North, but in Kaikohe, where the progression of the full plan is taking somewhat longer than had been anticipated, avalanche of private plan changes because people, if they are responding to their own development aspirations or they're responding to the market, then they will put in private plan change. But that equally raises efficiency considerations for the resource management practice as a whole, because if the public plan change is notified and on foot and hearings are underway, then there's a limit to which people's private plan changes, because the council, my understanding is the council can't have two plan changes on foot at the same time. So with a full plan having been notified and now a hearing, variation or continuing with the hearing timetable is really the only way forward.
Well, we're certainly aware of those issues, and we'll address them as we progress through. But I think we're certainly aware of those issues. I've got a couple of questions, so I might jump in now if you like. The centres hierarchy approach that you'd like to be recognised. I mean, one of the things that, and we're going to be getting evidence on this later on in this talk, is whether the Far North is a tier 3 community city, or whether it's even an urban environment in terms of the NPS UD. And that seems to be one of the NPSs that seems to be around for some period of time. When I say a long period of time, at least 12 months. So the question is, if Far North is not an urban environment, or at most tier 3, what is the importance of a centres hierarchy, given that it's on the lowest end of the commercial spectrum in terms of the range of urban zones that it needs to enable?
So again, I've just recently experienced this in Kaikohe. So your neighbouring district has just grappled with this issue as well, and it keeps coming up repeatedly in private plan change hearings in that district. And they had concluded that they were not a tier 3, that they're not an urban environment. And all of the planning evidence that keeps coming up is you do have urban environments. There's no such thing as no urban environment. We're sitting in an urban environment in Kaikohe at the moment. It's just the varying sizes, etc., as to whether or not the NPSUD comes into play. But what that does do is it provides a good policy direction as to what a well-functioning environment is. And so therefore, that policy outcome and that direction can be taken into account for urban environments that are not tier 1, 2, or 3. So that's the position that I would put to you, and that would be my opinion moving forward. Again, as I've said in my evidence, that having a hierarchy, it may only be 1 or 2 zones, or it may be identifying Kirikiri as an important growth area for this district. It doesn't need to be complicated, but at the moment there is nothing. You have a big void of silence in your strategic direction chapter. And as I said, this is very important for future consenting pathways and private plan changes, infrastructure direction, leading into your long-term plans, your infrastructure strategies, your asset management plans, everything to be linking in together and feeding in and working together moving forward planning for this district. So I do see it as an important matter for strategic direction moving forward.
Even if, from a legal perspective, even if there is a decision that Far North District doesn't need a complex hierarchy of centres, and perhaps it's just differentiating between a corner store and a township. What Ms McGrath and I have found in our professional practices, for example, a developer will come through with a private plan change seeking to establish themselves in the hierarchy that's available in the planning standards, and in fact potentially arguing that they sit higher. So we're both familiar with one where a developer argued that their centre that they were proposing, which would be a new greenfields or brownfields centre, would actually have a higher national planning standards status than the existing township that the community frequented. And so if your strategic direction of your plan doesn't address that, then it's open to people to come in and actually insert themselves and say, well, my new development is actually going to be the town centre zone, which trumps the mixed use zone and therefore is going to become the new centre of the mid-north. If there's nothing in the strategic direction about how centres have been approached, you can't rely on the Section 32, that all falls away as soon as the plan's operative. The plan has to stand on its own 2 feet, and it needs to not just set out how the district plan itself operates, but how it intends other people to operate under it for the life of the plan.
Thanks, I was just writing down some of your responses there. Thank you for that. Yeah, and I'll just another question regarding the NPSHPL. I'm assuming at the moment the Northland Regional Council is going about its mapping, but they need to be included into the RPS, and that's got to be done by way of a plan change. And then the districts are directed to incorporate that in a subsequent plan change.
Not through a plan change, sir. The mapping just rolls in.
It rolls in.
Mm-hmm.
Okay, well, but at least you've got one contested plan change process. And one can assume that may be quite contentious, and there would be full rights of appeal up and down, all the way to the Supreme Court and back down, back up, and there's a number of. So that interim mapping might be around for some time. I mean, it's almost wrong to call it interim.
We just had an Environment Court decision from Judge Stephen in Queenstown that the interim mapping is intended to apply as at the date of gazetting, as it was, and it is intended to be the answer until such time as regions map. So,
yes, and I think the wording, I read that decision because it's affected other things that I'm making decisions on at the moment, and you know that says irrespective of its accuracy, That's the holding pattern for this interim process. And I'm thinking about, well, how long is this interim process going to be? So, and it would mean that any, so this is an effect, this mapping is an effect, and the council will be bound by it, notwithstanding what it's in this proposed plan.
And the objectives and policies.
And the objectives and policies, right, provide pretty, well, it's not even assessment criteria, it's pretty directive about what things can happen on highly productive land and what can't. And the pathway is quite narrow. So it's almost as if there's a de facto HPL provision that the district plan is subject to, whether it's in the proposed plan yet or not. And I'm assuming the NPS HPL will be incorporated in later topics. And the council is going to ignore it. They're going to introduce it. Question is whether it needs to be recognised at the strategic level. And is it your evidence that that matters in the NPS HPL need to be recognised at the strategic level, or is it more practical that it be addressed at the rural zoning?
So I think they can be addressed at rural zoning, but the objectives as notified are inconsistent with it. So there should be language to make sure that the objectives are consistent with. If not give effect to, then the give effect to must come in at the rural production zone.
And can you just remind us what are the specific objectives that you're, I'm assuming they're rural environment objectives?
Yes, so they are the rural environment objectives. So
this is regarding they have a reference to highly productive land, and that's the definition that you say is inconsistent. But we're going to have a topic which is just on definition. So yes. I'm assuming it's not deliberate. It's just we're going to
to that point.
We've got, there's always a slicing and dicing when it comes to how you hear a district plan, and it's obviously a topic that we'll get to.
Yes, sir.
So what we could, I'm not sure, but we could anticipate that definition could be amended at that point, and that would possibly address your concerns. The definition
not with the
of
objectives, sir, not as they're drafted in the strategic direction, but yes, that could solve some of the problems with giving effect to the NPS HPL moving forward. You'll hear from me on this in another hearing coming up shortly. I say it's very important for you to understand the scope of how a zone is applied when you're thinking about effects management for that zone and what should for the content be of the zone. So understanding the scope of a definition, for example, such as highly productive land, will have a huge impact for the horticulture zone and how it's applied across the district. So I think it is very important for you to understand that you've got serious problems with the definition as it is, and the zone of horticulture zone when you're looking at these objectives. So in particular, objective 2, protection of highly productive land from inappropriate development to ensure its productive potential. And so in my opinion, that is too open to be consistent with the NPS HPL, which is focused strongly on land-based primary production. And so there is a nuanced difference between those terms and the definition and what that manages. And so, as you quite rightly identified, the NPS HPL is very restrictive. It's very directive in its application, and making sure that that flows into the plan is important so that you don't have unintended consequences of what you're capturing. And again, you heard much on the rural environment objectives this morning on that matters.
So specifically your question about does it matter? It doesn't need to be captured in the proposed plan because it sits as the NPS HPL anyway. Ms McGrath's evidence had addressed the efficiency and effectiveness aspects of that. If people are coming through with resource consents or private plan changes and the newly minted, in the Judge Smith's phrase, the newly minted district plan objectives, policies or provisions are inconsistent with the NPS HPL, it creates inefficiencies and costs and delays in the process where arguments are being had, particularly at resource consent stage, where you're having to do those alignment conversations with counsel and witnesses and evidence when this is the opportunity to actually make those align. So because the give effect to aspect of it sits there, in my submission and Ms McGrath's evidence, it does need to be done. If it was not done in the proposed district plan, there is also the efficiency and effectiveness issues that flow from that for resource consent processes going forward.
Yes, okay. And I'm assuming that one of the issues you have with the definition is the inclusion of class 4.
Yes, sir.
That would possibly be a big part of it. Okay. Well, I mean, of course, the other news that we all know is that there is a cabinet paper that's clearly stated that it's the government's intention to remove class 3 as well. I'm not limiting what, I don't necessarily reject what you say about section 74 of the Act, but we know, but the interesting thing is that they say that cabinet paper says that that's going to conclude by March next year. I mean, that's good luck. But we're probably going to get some direction on that national policy instrument, I think, before these hearings close, and even maybe before we hear the rural chapter. So I think there's always problems with sequencing and slicing and dicing and decide what you're going to hear first, and there's always arguments as to why you're hearing that first when it could implicate that. I think we just have to wrestle with that as we go through, and the dynamic planning environment that we live within at the moment.
Council have an active obligation on us under our rules of practice that frustratingly we have to alert decision makers if the law or one of the policy documents changes before you issue your decision. We have an active obligation to alert you of that, and or the panel could proactively say, look, we're aware that this has now been, this legal change has now been made, and we invite those submitters who are interested in that to send us anything in a coordinated fashion. So I think there's ways for you to deal with both those NPS changes and also statutory amendments. And you could deal with that by receiving or by proactively inviting those who are interested to address you. Could be in writing, could be on the papers. Yeah, it's going to be a long process for the plan anyway. So.
Thank you. Let's go to the question.
Well, after that challenge that was faced down, I thought we were all going to go home. It sounds like we might have it's going to be a bit of a moving feast for a while. So.
Plan is a long process, and nothing is
It's been a long time already.
Nothing is unfixable. You have you have a full plan, and you have a broad scope of submissions. Everything is resolvable.
Yeah, I mean, you can't avoid taking a reductionist approach to hearing the submissions, but you always know that they're more horizontally integrated than the linear process that we're committed to. But I understand your legal submissions, and we're going to be doing our best to reintegrate other matters into it. It may be that we issue further direction as we go along.
Thank you, Mr. Chair. So just to clarify what you're seeking today in terms of the lack of vertical integration, and essentially what's being outlined by legal counsel is the first three elements: delete the horticultural zone, review commercial zones, and rezone getting fringe to enable commercial activities. Those themes under the strategic direction, you're asking to redraft the plan. I'm sure that those are outlined. And I'm not sure from staff about the timing that we're going to get that report offhand. I think it's sooner than the middle of next year. I think it's soon. So it'd be really important for us to get that timing. But in terms of the questions about your timing, because the offer of redrafting the plan before moving into further hearings is what's been suggested today. In terms of the timing for yourself to come back with further suggestions, if we were to be open to that, what's your response to that?
Well, I'm not certainly to redraft the plan to council, but I'm happy to work with the reporting planner if that was the direction from the panel, to if there were solutions that were being considered, happy to work together on that and provide responses to and inputs.
I think for me, really, it's your legal counsel has highlighted the forward planning of the timeline of the proposed hearings and how the proposed change that's been suggested today would work in with that timetable or not, given the body slam suggestion that is from my fellow commissioner.
And yeah, I'm not sure that we intended to see this as a body slam. There There are a number of submitters who read the section 32 analysis for the plan and thought that there was less detail than they had intended to see. As I say, most of us are pragmatic. We do this day out and you work what you have and you move forward. 32A is an ongoing obligation. No matter how comprehensive a 32 is before a plan, it constantly has to be updated anyway, because there are always inevitably changes. I think that my flag for the panel is that, particularly in terms of fairness to submitters, if the rezoning hearing is going to have a significant new piece of material that is relevant to the 42A recommendations, that submitters be given a fair time and opportunity to respond to the material in the 42A recommendation, and that may be by bringing timeframes for the 42A earlier. The other thing is that in terms of a recommendation to reject submissions seeking assent, because centre's hierarchy on the basis that future information is to follow, I would invite the council in the reply on this strategic direction topic to reconsider whether those are recommendations to reject or whether they are recommendations to defer those submissions to a later topic. So it may be that it actually takes care of itself.
Okay, well, we could possibly ask council office to clarify, because I mean, I think I interpreted that rejection was a rejection to include it in the strategic section, but not a rejection of it being considered later on. And I think that's, you wanted to keep that part of the door. I mean, I know you disagree with both, but you want to keep at least that part of the door open. So does council officers want to clarify what that rejection recommendation meant in that sense?
I think the chair has correctly picked up the intent of council position as the council, the reporting officer, and council's position as a whole.
Yes.
If new information comes to light through subsequent hearings, and as we highlighted, there is the housing and business assessment that actually is going to be workshopped with elected members on the 4th of June. So it's not a case of we're looking at releasing that information middle of next year. And it has been informed through the Burl business land assessment and also the in-house latent capacity assessment as well. So it's not a fresh piece of work, it is in response to submissions.
And are you able to give us, I mean, you're not obliged to, but are you in a position to give us an indicative timing for the release of that work?
It will be subject to obviously the internal workshop with elected members, but we would hope that council officers will be able to start working with a confirmed report June, July. We'll have to work through when the information, however, gets released and the methods in which we'll do that. We obviously don't have any intent to withhold the information. We want to give everyone the ability to obviously have that inform their submissions. We just have to work through that process.
So look, it seems to me that your submission, I mean, often when it comes to making recommendations on submission, you're faced with a binary option. I don't think that was the intent of the officers to say that if submission is rejected with regards to release of what another chapters, if that gives you any confidence going forward on that matter.
Thank you.
Well, I'll just see if we've got any other questions to follow up with. Oh, thank you very much. Very well prepared legal and submissions and planning evidence, and certainly heard your message loud and clear.
So in terms of timing for the afternoon, I note that Ms McGrath, without me, is the next submitter who was due to appear after the lunch and adjournment. So if you wanted to clarify your timing for the panel's lunch.
I think what I think we'll do is we'll have the lunch break now. What time are we now? Gosh, we're at 1 o'clock. So look, I still think we need an hour for lunch. Now, right. Maybe we'll come back at 2. We'll just crib back 5 minutes. How does that sound? Sound fine? And with the other submitters? Then we'll adjourn then until. Thank you so very much.